I'm Kagiso Mekwa, the student counselor based in the Florida campus. I'm the one running the program for today. And I'm really excited for this workshop that we are about to start now. And I believe that you're also as excited as I am, because this is a unique workshop that we never had before. But what makes it more special is the presenters for today. The people who are going to be presenting for us are our very own law students who are very well versed in the subject matter, to try to take us through the program for today and share with us. But without further ado, I was just appetizing you to prepare yourself. I believe you have prepared your questions. I believe you will leave today very much informed and very much alert, and also more wiser than you were. I'm not saying you were not wise, but you have added more knowledge and more insight into your arsenal. So without any further ado, I want to invite over Ms. Ayanda Twala, who is also our intern at our Ekurhuleni campus in the student counseling department, to do her part of welcoming everyone and to tell us the purpose for today and what we are on about. So if Ms. Ayanda is in the space, can we please give her a round of applause just to welcome us and to take us through. But before that, I will just to do some house rules, just requesting that we all mute our mics, and we will be allowed an opportunity to post questions on the chat, because we have 3 presenters. So it will be 4 sections of presentations, and then when the first speaker is presenting, you can post the questions on the chat. When she steps off the mic and give the second speaker the opportunity, she will be able to respond to some of the questions on the chat. So let's put our questions on the chat. Let's take down details, and there's lots of acts and forms that need to be filled with regard to wills and other things, and estates and trust. So you are never too young to start a will, or never too old to have an estate or a trust opened. So Ms. Ayanda Twala, please take the virtual floor. Thank you.
Thank you, Mr. Kagiso. Good morning, colleagues. Good morning to our presenters, and also good morning to our law students. My name is Ayanda Twala, and it is my honor to open today's Will workshop. I would like to begin by thanking our program director, Mr. Kagiso, for granting me this opportunity. A warm welcome to all of you, our fellow law students. This workshop has been designed to enrich our academic journey by bridging theory with practical application. As future legal practitioners, understanding wills, marriage contracts, trust, and estate administration is vital to our professional development. So these areas form the foundation of private law practice and are essential in advising and protecting clients. So the purpose of today's session is not only to expand our legal knowledge, but also to prepare us for real-world application. By learning from our presenters, we will gain clarity on procedures, legal requirements, and practical challenges that arise in these matters. I also encourage you to actively participate, ask questions, and use this platform as a stepping stone towards your professional growth. With those words, it gives me a great pleasure to declare that this Will workshop is officially open. Thank you so much, Mr. Kagiso. Over to you.
Thank you so much, Ms. Twala, for the warm welcome. In Setswana, meaning that you are free to indulge and also to participate. We're having the first presenter who's going to be presenting for us in terms of the wills. I don't know how many of you, if maybe I see by the raising of hand, I just want to do a short survey to check how many of us have wills. How many of us here in attendance have wills? I hope the presenter is looking at the screen to check. I see we only have 11. We have only 11 people who have wills. And now it's a serious question that was going to be addressed. Why people have wills? Why only few people have wills? And why don't you have a will? What is the importance of a will? So we have Miss Ayanda in attendance. Miss Ayanda in attendance as the welcoming. She gave us the way forward. So we're gonna be inviting now Miss Moleboge Mpheko, who is also a final year LLB student at the University of South Africa, and then also she also holds a diploma in law and is certified and is also a certified in compliance and risk management. Currently, she is active in the anti-money laundering space and serves as a student mentor in the College of Law, supervised by the Florida campus of UNISA. And she is also supporting her peers in their academic journey. She has both academic and practical exposure and experience in wills and also in estate administration, and therefore brings a valuable perspective to today's discussion. So the person that we are bringing to you today is Chansa, who deals with money laundering and other things.
Thank you very much, Kagiso, for the warm welcome. I really appreciate it. Thank you to Ayanda for telling us why we are here today. Today's presentation, I'm going to be presenting on wills and later on estate administration. I hope everybody finds this presentation informative. You can ask questions in the chat box and my colleagues will be assisting with questions, and others I will get to them at the end of the presentation. Thank you. So firstly, testate versus intestate succession. Testate succession is when a person dies with a valid will and your estate is distributed as per your wishes. Intestate succession is when a person dies without a valid will and your estate is distributed according to the Intestate Succession Act 81 of 1987. So for example, without a will, your spouse and children may have to share property equally. It doesn't really put into account your wishes. Intestate death. When a person dies without a will, they are said to have died intestate. In South Africa, the Intestate Succession Act 81 of 1987 applies, and the estate is distributed according to the fixed legal rules rather than the deceased's wishes. So when you die without a will, it doesn't matter if you told your child that she can have your car or your son can have your piano or your musical instruments. Without a wish, everything is distributed according to the intestate succession rules. So word of mouth does not work when it comes to your estate. Simply telling people that this belongs to you and I pass away or this becomes yours does not work. So here's what happens when you die intestate. This is without a will. Firstly, the death must be reported to the master of the High Court or a service point of the master in the area where the deceased lived. So some areas do not have a master's office, but they do have a service point for a master. If your estate is small, which is under 250,000, the master may issue a letter of authority. If larger than 250,000, a letter of executorship is issued to appoint an executor. So here's distribution. So according to Intestate Succession Act, the estate is divided among surviving relatives in the following order. So your surviving spouse and children inherit. The surviving spouse is entitled to grades of 250, which we call the child share. A child share in the estate is divided equally between the spouse and all children. So let me just give a quick explanation of that. If you are married in community of property and say you have an estate value of R1 million, your wife gets her 500,000 in terms of the marriage regime. She gets her 50% because of the marital regime. However, she also gets a share in the remaining 500,000 rand because you do not have a will. So now we are dealing with your share of the estate. So your wife gets her 50% in terms of the marital regime. If you are married, your wife or your husband gets their 50% share. in terms of the marital regime. So if you're married in community of property, they get their 500,000 rand. And then the 500,000 rand that is left will be split between your partner and your children. So if you have 2 children and a spouse, we divide your 500,000 by 3. I think that will give us round about 100 and something. However, because it is mandated by law that the spouse gets 250,000 rand as per the child share, from the 500,000 rand, we remove 250,000, which goes to your wife, and the remaining 250,000 is shared among your children. As you can see with the example here, if a man dies leaving a wife and 2 children with an estate of 600,000, this is after it was shared, so the estate was 1.2 million. Child share was 600,000 divided by 3, and that is equals to 200,000. Since 250 is greater than 200,000, the wife gets 250,000. The balance 350,000 is divided between the 2 children. So if you have an estate value after sharing your estate, after paying everything, and after your wife receiving her share, you are left with 250,000. Then the 250,000 solely goes to your spouse. Your children do not get anything. So it is important to get a will, because this will be applied, and this means your children will not get anything if after paying off your debt, if after everything you are left with 250,000, it goes to your spouse. So if a person dies and there's a spouse but no children, the spouse inherits the entire estate. If there are children but no spouse, the children inherit the estate in equal shares. If a child has already died but has surviving children, the deceased grandchildren, they inherit that child's share per representation. So if you have children and one of your children died before you, or one of your children dies after you die, their children get a share in the estate. They are representing their parent. We call this issue by representation. They are seen to be representing their parents in your share of the estate. So if a person dies with no spouse or children, the estate goes to the parents. And if only one parent is alive, they get half, and the other half goes to the deceased siblings. If no parents, the estate goes to siblings, nieces, and nephews. It goes to your siblings first, and if one of your siblings isn't there to inherit, then your nieces and nephews get their parents' share. If you have no relatives at all, the estate becomes bona vacatia and goes to the state. So it is important to note that you cannot take your brother's stuff while your brother has a spouse and children. You are way behind in the line. You cannot claim your sibling stuff when you have parents and when your sibling has a wife and children. You are like 4th in line. It is very important to note, even if your brother's wife cannot drive and you feel like you deserve the car because you were helping your brother fix it, there is a line when it comes to inheritance. First is the spouse, then children, then parents, and then siblings. I hope you're all clear on that. So practical consequences of dying without a will. The deceased has no control over who inherits. So when you die without a will, you don't have control as to who inherits what. The state and the law decides and who gets an inheritance. So if you feel like you don't want this person to inherit, and you don't want this person to inherit, you don't want this person to get any money from your estate, it is very important to get a will so that you can stipulate that, because when you pass away, you no longer get to make any decisions because you did not leave anybody with a will. Now the decisions are made by the law. Also, it may cause disputes among family members. Like I said, you giving one of your children a car and telling them this by word of mouth, and when the time comes, the child says, "This is my car, mommy gave me this car," whatever. It causes disputes amongst family members. This is the reason why a lot of estates still haven't been administered, because of disputes amongst the beneficiaries. Minor children's inheritance must be paid into the guardian's fund managed by the master of the High Court until they turn 18. So if you have money or an inheritance for your children and you do not have a will that stipulates what happens to the inheritance, then it is paid into the guardian's fund that is managed by the master of the High Court until they turn 18. So this means your money will be dealt with and managed by the government. If the deceased lived with a life partner but not married, that partner may not inherit unless they can prove a legally recognized claim, e.g. maintenance, or if the court recognizes the relationship. There are currently some rules that are coming into play, some acts that are coming into play to recognize or to legally recognize life partners so that they are able to inherit, but that may be discussed on another day when the act does come into play. So these are the type of wills that we have. We have a simple will. This is your will that you will do and say, I leave my estate to my children. I leave my estate to my father. Should a child not survive me, should I pass away with my children, this is what happens. And then there's a joint will. This is usually done by couples. Couples usually get joint wills where they put in what they want inside their will together. They share a will. A living will, which is not legal binding in South Africa, but may help to decide what happens to you. So a living will is a will where you give instructions on what happens to you if you're ever in a coma, you're ever in a ventilator, you're ever in an accident. Would you like to be kept on a ventilator? Would you want your body to be kept on a ventilator? Do you want to donate your organs and so forth? But it is worthy to note that if you do not tell people that you have a living will, then things will be done or donations may be made over your organs, or you may be kept on a ventilator because the family decided, because they aren't aware of your living will. So your living will is there to tell your family what should happen in the case that you're in a bad accident, in the case that you need an organ donor, in the case that you need blood transfusions. I know some people do not get blood transfusions because of their religious values. Those are the things that you add in your living will to say, I do not want a blood transfusion in the case that I am hurt and need blood and so forth. And a digital will, which are emerging concepts. These are wills that are done usually by your content creators to say, this is what happens to my social media accounts. Should I pass away, my social media accounts should be sold, and so forth and so forth. So digital wills are usually done by your content creators. It is something that is emerging because the content creation scene is actually growing. I hope we're all together. I hope we're all still together. Why wills are important? Firstly, wills are important because they prevent disputes and delays. So when you don't have a will, there will be delays in the administration of your estate because it first needs to go to the master's office. It needs to be registered. The master needs to appoint an executor and so forth. It also prevents disputes. Everybody knows what they get because of your wishes. Your estate is divided in ways that you would like it to be divided. It also protects dependents and appoints guardians. Some people are single parents. The other parent is not in the picture. You are able to appoint a guardian for your child. And remember, before appointing somebody as a guardian for your child, please let them know. Do not just appoint somebody as a guardian for your child because they are your sibling or because they love your children. Appointing somebody as a guardian for your children is really a major thing. You are asking this person to parent your children. You are asking this person to take in your children. So before you appoint somebody as a guardian for your children, make sure to discuss it with them first so that they understand what this entails. When appointing a guardian for your child, make sure this person has the same values as you and they will raise your child in a way that you would raise them. This also helps to distribute sentimental items. You're able to distribute sentimental items. I know some people are collectors of watches. Some people are collectors of vintage cars, collectors of figurines. you're able to distribute these sentimental items to the people you would love to have them. You will know who shares a love for your gun collecting or your vintage car, and you are able to give that person what you want because you know they will care for it in a way that you would have cared for it. Myth busting: wills are not just for the rich. Everybody can and is allowed to get a will. If you have anything that belongs to you, you have an estate, you are able to get a will. If you have things that you'd like to go to somebody, you have a house, you want your house to go to a certain person, you can have a will. You don't have to have a large estate. Your estate doesn't have to be over 5 million. You don't have to have a lot of assets to have a will. A will is there to protect you and your assets and to make your wishes known. Validity of a will must be in writing. Your will must be in writing. That's the first thing. Your will must be signed by a testator on every page. So you must sign your will on each and every page where there is writing. Your will must be signed in the presence of 2 competent witnesses. So you can't sign your will at home and then take your will to work and ask your colleagues to sign it. Everybody must sign in the presence of each other. There mustn't be any blank spaces on your will. No blank spaces where somebody is able to add information in that will or edit it. So there mustn't be any blank spaces. The testator must be 16 and above and mentally competent. For you to have a will, you must be 16 years and older and be mentally competent by the time you have your will drafted. So this is, you're not signing your will under duress. You aren't mentally unfit at the time. You must be mentally competent and be 16 and above. Common mistakes that invalidate wills: beneficiaries or their spouses signing as witnesses. So we have a law against spouses signing as witnesses. If your spouse is also a beneficiary in the will, they cannot sign as a witness. Beneficiaries also shouldn't sign as witnesses because it can be contested in court. So if somebody is a beneficiary in your will, they cannot sign as a witness for a will because somebody else can come and say, no, this is not how it was. This is how it should be. They were under duress. They were forced to do this. Then it will invalidate your will. Missing signatures on 1 or more pages. If there's a missing signature on a page, the master may take this to mean this page was added later after the deceased passed away. So there mustn't be any missing signatures on 1 or more pages. Every single page must have a signature. Handwritten alterations not signed and dated properly. So if you want to cancel a beneficiary on your will, you can cancel it out. Make sure right on that line where you did a cancellation, you put your initials or you sign and date it so that we are aware that you made the cancellation. We are aware that you made the alteration. Will not dated. Your will needs to be dated because it creates disputes. There are people who have written 7 or 6 wills. If your 7th will removes the beneficiary that is there on your 6th will and it is not dated, the beneficiary that was removed can come and fight and say, that is not your last will. The last will, they were there on your last will. So always make sure that you date your wills so that we are aware which will is the final will. Testator not sound of mind at the time of signing. So some people usually will sign their wills or will have a will rashly done because they're in hospital and they feel like they're passing away. They will alter their will and stuff like that. And we can fight, or beneficiaries can fight and say you were not sound of mind at the time of the signing. So whoever signs the will needs to make sure that they are of sound mind when signing the will. Revocation of a will, this means your will does not exist anymore. It's not a valid will. It doesn't exist. You have revoked your will. Your will is automatically revoked by signing a new will. So if you draft a new will, New wills will usually have the wording, I revoke all previously signed wills and codals. So this is your new will. So automatically when drafting a new will, all of the other wills don't exist. So if you destroy the will intentionally, if you tear it apart, you have destroyed the will. That will does not exist anymore. Marriage can revoke a prior will unless made in contemplation of the marriage. So a marriage can revoke another will. Some people have wills, but remember, these are things that will be contested in court. Some people have wills, and their wills include their ex-wives or children who have passed on. Your marriage can come and revoke that will. If your ex-wife is in the will, this new marriage can come and revoke. A judge can decide this will is no longer valid. This will no longer works because you got married. Divorce, ex-spouse is treated as if they have died before the data unless the will says otherwise. So your ex-spouse does not factor into your will. They are treated as somebody who passed away, somebody who no longer exists, unless you state in your will that this is what's happening with your ex-spouse and this is what's happening with them. They are treated as somebody who does not exist. So where you can get a will done, you can get a will done at an attorney, you can go to a bank or the legal aid. They can assist you in drafting your will. So there are terms and conditions to add. There are fees with each respective bank. That is information you can get with each respective bank that you want to go to. Non-profits during National Wills Week, which is on the 15th of September, there are non-profit organizations that offer will drafting where they will draft your wills for you. Online platforms, I know there are online platforms that charge a certain fee for them to have your will drafted. You can also get a personal will drafter or paralegal service providers who can and will draft your will for you. Will registration. So will registration is not compulsory in South Africa. You can store your will, however, with an attorney. You can store it with a bank, depending on what the bank's rules are to storing their wills. But I know banks will only store your wills if they are drafted with them. So you can't have your will drafted by somebody and then go ask your bank to store it for you. Or the Master of the High Court. Master of the High Court does store your wills, but that is a lengthy process. And always inform your family or somebody of the location of your will, because you do have a copy of your will. If you're going to put it under your bed, inform somebody that that is where your will is. The executor of the estate, this person is the person who manages estate administration. So when you pass away, you can nominate an executor in your will. This will be the person who deals with the managing of your estate after you pass away. The person will be confirmed by the Master of the High Court when you go register the will when your will is registered after you pass away. The person can be family, an attorney, or another professional who deals with wills. Like I said before, you can nominate a guardian for a minor children in your will. If not nominated, the court decides, so somebody can come and say, no, I want to be the guardian, and they do not have your children's best interests at heart, because remember, the guardian also does have access to the funds that you leave for your children. Funeral instructions, preferences may be included in the will. It is not legally binding, but it can guide the family in what you want. Some people are working in provinces that are far away from their home provinces or where they are born or where their families are. If you're working and you have a family or a spouse or children in Pretoria and you wish to be buried in Pretoria, yet you come from KZN, those are things you can add to your will. But also remember, it is really to remember that wills aren't things that people remember on site when you pass away. So this might come up months after you pass away, a week after you pass away, and you are buried. So it is really worthy to remember to inform somebody of your will, where it is, and where they can find it. So it is not legally binding. However, funeral instructions can help your family decide if you want to be buried by a specific church, if you want to be buried at a specific place, if you want to be cremated and you want your ashes to be thrown somewhere. These are things that you can add on your will so that people know, but it's also worthy to inform people of those instructions. Digital assets, this includes instructions for digital accounts and social media. Like I said before, this is something that is emerging. You can include instruction for digital accounts. Do you want them to be closed? Do you want them to be kept as a remembrance? Do you want your social media accounts to be sold? How much do you want them to be sold for? And you can appoint somebody to do this for you, who will solely deal with this for you. If you want your sibling who is more versed on social media or digital assets, you can ask them to delete them, to sell them for a fixed amount, or so forth. And lastly, tax and debt consideration. We will come into estate administration. However, it is worthy to note that if your estate is worth over 3.5 million, you have an estate duty of 20%. So you have to pay 20% for tax if your estate is more than 3.5 million. Debts must be paid before inheritance. So before anybody gets the share of the estate or everything, your estate must pay off your debts. This is your house, your car, if you have any clothing accounts, if you have any loans, that is paid for before the estate is shared. So not prior, it is paid before the estate is shared. Also, something I forgot to add was your life policies, your funeral covers, and so forth. You can add them into your will to say, I have funeral covers with Sanlam, with Avbob. However, it is worthy to note that funeral covers are, life covers are governed by their own rules. So usually when you open a life cover, you have to nominate beneficiaries. So that will be dealt with separately. Your life cover and your funeral cover and so forth do not really form part of your estate. However, it will come into play if you say they must be taken into a trust. So you can't nominate people on your life cover as per the life cover rules, and then in your will come and change that and say, no, I'm nominating this to my nephew and so forth. Yet on the cover, when you open the cover, the beneficiaries there are your sister and your children. I hope we're clear, and that is the end of my presentation. Thank you very much.
So I just want us to appreciate Moleboheng for provoking us, for thought-provoking presentation. Now the question is, now what's going to happen to my clothes? I know I have very expensive clothes that I don't want anyone and everyone to have them. So can I include them on my will? I had Moleboheng presenting saying that we also choose the place of your burial. You also choose who you want to put in your will. He says, she does not say you cannot put your ex, but she says that it should be stated there. Even if you separated, maybe you still love your ex, you want them to have something. Maybe they are raising your children there, you still want them to have something. So those are some of the questions that were brought forth. So I'm going to ask Gloria to open the mic for Zandile Mtimkulu and Witumelo Masilo to ask their questions.
Moleboheng, thank you so much for your presentation. I have a question because I'm currently going through a situation where my late husband passed away. He didn't leave a will. He was an advocate, if you will believe me. So now the question around the value of the estate, if it's more than 3.5 million and that 20% that fee that has to be paid. My question is, when the debt of the estate is being collected and it now turns out to be of a value that reduces the estate, are you still liable for the 3.5 million, or do they now consider what the value of the estate is after all the debt has been taken into account? Thank you.
Okay, thank you very much for your questions, Andile. So the 3.5 is taken into consideration. I will be discussing this a bit later via the estate administration. However, the 3.5 is taken with the value at the beginning. So if the value drops down to 1 million after debts are paid, the tax would have already been paid. I think that's the third step of estate administration. It would be paid before everything else. Tax is at the top. SARS does not play with their money. They take that before any other debts are paid. And if there isn't any money for debt and stuff, remember we have assets that are immovable, then those are sold to recover the money. So your house will be sold to pay debts. There are things that banks are doing, whereby you owe 1,000 rand and your house is sold to pay the 1,000 rand. So you need to make sure that your estate is higher than your debt. I hope I've answered you.
So my question is, maybe you will also cover it when you get to the administration side of things, but I just want to ask now, ne? Say a couple is married and then they are married in community of property, but then the wife came into the marriage with kids, and then the wife passes away first. Now, after the wife passes away, the husband is then left, libana, and then the husband, yena, ha a etsa will, a be a kenya ditlogolo tsa bana ba hae fela. Will it be possible for bana ba the wife as well to contest the will? Because you find that hane me a tlhokafala, azang ba thole their portion, the husband azang ba distributed the estate, like they just let everything idulele fela jwalo. The husband continued running everything in the household, le ditjhelete tsa mosadi, even the portions tsa bana di ile di a dula with the husband. Now when the husband passes away, there's no parents, but then the will enter them a yentseng o kentse ditlogolo. Is it possible for the kids to contest the type of will? That's my question. Thank you.
My question is just around married couples, right? If it's community of property or ANC, is it advisable to do the will as a joint will, just regarding the administration process if the couple gets divorced? Because I've been drafting wills separately for couples unless they agree to have it as a joint will. Thank you.
To answer you, Boitumelo, the estate should have been shared from the beginning. If the estate was not shared between the children and the spouse, and then the estate went to the spouse and they continued with, your daily tasks, the maintenance of the house and so forth, and now the person has passed away, unfortunately, it does become problematic to try and claim from the estate. However, you can go and contest the will, and you need to have very valid grounds. It is possible to contest each and every will, but whether you will come out victorious is the question, because everything should have been shared from the beginning. So I think it's worthy to note that when a person passes away, we shouldn't just assume that the estate goes to the husband or the children. We need to go and register the deceased estate with the master's office. There are people sitting in houses that are still in the names of people who have passed away because they just assume that no, the house now belongs to us. It is important to report the estate from the beginning, because now when the person who inherited the estate has passed away and then they had a will, it becomes very problematic. However, you can contest it. Whether you come out victorious is another question. To answer Kyle, you can have a joint will for couples, whether they are married in ANC or in community of property. You can have those joint wills that will state the couple, or I am married in or out of community of property. You are able to actually get those wills done. A lot of people choose to have those wills for administration purposes because it costs more money to have two separate wills. And when the person passes away and they have a joint will, the joint will be changed to a single. It will be read as a single, even though it is a joint will. I hope I've answered you all.
Molebogeng, before you go, I think Ms. Smith posted her question there asking, do spouses pay tax on inheritance? If we can close with that question. Do spouses pay tax on inheritance? Then we let you go for now until you come back.
Yes, everybody is liable to paying tax on the estate that they have inherited, spouse or child or not. You do need to pay tax on the estate So long as it is more than 3.5 million, the estate value is more than 3.5 million, you have to pay tax. Remember that the tax comes from the estate, so it's not coming from your own pocket, but the estate. So the estate will pay its own debts, it will pay its own tax obligations and everything before it becomes yours. Before you inherit it, it has to pay for debts and everything. What is left after the tax and other obligations is your inheritance.
My next speaker here is an LLB student waiting graduation. She's almost at the stage. She's just waiting for that hood for them to bang on top of her head with that magic wand. And she has completed her higher certificate in law. Before she did her law degree, she's graduating now for her LLB. She's also the Deputy Secretary for the Black Lawyers Association for Student Chapter, and here in UNISA at the Florida campus. And she's also job shadowing with Advocate Zaza, a legal mentee. So colleagues, can we please welcome and appreciate the future advocate Masakona Manenje, who's coming to tell us about the marriage contracts. She said there are Christian marriage contracts, and also there's also Muslim marriage that we need to know about, because now we are a beautiful rainbow nation. So anyone is allowed to marry anyone, cross culture, cross religion. So we need to be aware of what happens in there. Ms. Advocate Masakona, please come into the virtual platform and we will be with you just now. Thank you so much, Advocate Masakona.
I am Masakona Manenje, as introduced. We're going to talk about marriage contracts, as well as how they're incorporated in terms of wills and estates. Okay, so we have three marriage contracts that recognized under the Marriage Act 25 of 1961 and the Civil Union Act 17 of 2006, which is your marriage and community of property, marriage out of community of property with accrual, and marriage out of community without accrual. So when we deal with your marriage in community of property, this is a default option where if there's no antenuptial agreement prior to the conclusion of your marriage, meaning that all assets and debts are shared equally. So if you came with R1 million of debt and your spouse had 0 debt, when you're married, you guys share those responsibilities and baggages if you have assets and so forth. One of the biggest advantages of this marriage regime is it's simple and cost effective. But the big disadvantage on this one is one spouse has significant debt or financial instability, meaning that it's shared responsibility. Okay, so in terms of wills and estate, a community of property marriage results in a single joint estate with equal shares and joint liability for both spouses, meaning that should one of the spouses die, the estate has to be frozen and wound up. The surviving spouse is entitled to 50% of the joint estate, which does not form part of the deceased estate for distribution under a will or testacy. This was also mentioned by my colleague in terms of distribution of estate. So you prioritize the remaining spouse before your children and everybody else. This is why it's important to then have a valid will that is well drafted and stipulates each and every single thing that you want. In absence of a valid will, the surviving spouse, half of the joint estate will be distributed according to the rules of interstate succession. When we're dealing with marriage of out of community of property with accrual, so this is each spouse keep their own assets but share in the growth of the estate, meaning that before you're married, you keep whatever that you had before the marriage. But when you are now married, everything you share contributions equally. should there be a divorce or death, the spouse with less accrual can claim half of the difference. In essence, each spouse retains their pre-marriage assets and liability, but the growth of the estate during the marriage is shared equally. Opposite was said about out of community of property without accrual. Each spouse keeps their assets and liabilities separate throughout the marriage with no sharing of any growth. This regime is based on full financial independence and no sharing of wealth accumulated during the marriage. So in terms of wills and estate, marriages out of community of property are significant choice with implications. This regime keeps the spouse's estate separate by signing an antenuptial agreement before the marriage is agreed upon. The accrual system allows for the sharing of any growth in the spouse estate during the marriage, ensuring the economically weaker spouse is not left destitute while maintaining separate control over their finances. When one spouse has died, the surviving spouse has a legal claim against deceased estate for their share of the accrual. This is a creditor's claim, meaning it must be paid out of the deceased estate before inheritance is distributed to beneficiaries. The freedom of testation is limited by the surviving spouse accrual claim, which must be settled first. So it's important to understand that when you're dealing with the accrual system or the marriage regime where it's out of community of property, there are more stipulations as to how your assets will be distributed should you not have a will. The Maintenance of Surviving Spouse Act allows a surviving spouse to make a claim against the deceased estate for reasonable maintenance if they are not provided for in the will. A well-drafted will is crucial for this marital regime as it ensures that the surviving spouse receives an inheritance as they have no automatic claim. Unlike in community of property where it's an automatic thing, in out of community of property, it's not automatic. You still have to go to the master's office and say, this is what I want to claim for, or this is how things need to be distributed as per the agreement or the marriage regime or the antenuptial agreement. Okay, antenuptial agreements or contracts. Basically, it's a legal document that allows couples to tailor-make their financial future and protect their individual interests within the marriage. This must be signed before the marriage by both parties, 2 witnesses, and a notary public. This is very important because if all of these steps are not followed, then you do not have a valid antenuptial contract. It must be also registered in the Deeds Registry's office. This allows couples to customize their marital property regime to suit their specific needs and circumstances. Addresses issues like assets ownership, debt, responsibility, and division of property in an event of divorce, but not just divorce, in an event of death. You can stipulate things, how things need to happen, or you can say, after this, I will then have a post-nuptial contract. Customary marriages. This is more complex because a lot of things happen. We have different customs. So customary marriage is entered into according to the customs and traditions of indigenous people in South Africa. It is recognized under the Recognition of Customary Marriage Act 120 of 1998, which came into force on the 15th of November 2000. It gives women in customary marriage the same status and protection as women in civil law marriages. It also introduces equality in the marriage relationship. So when you're in a customary marriage, it's automatically, if you don't have an antenuptial agreement or you did not register it, you are automatically married in community of property. In accordance to the traditions of the couple's community, these marriages are honored with festivities including lobola, bride price, bargaining, and rituals. The marriage must be freely accepted by both parties. Each spouse or every spouse must be at least 18 years of age. According to local customs, customary law permits polygamous marriage, which I will further explain in the next slides. In the absence of an antenuptial agreement, the marriage is regarded as community of property, as mentioned, which means that debts and assets are divided. In the event that one partner passes away without a will, spouses and children are protected by the Interstate Succession Act. Civil divorce procedures are followed in customary marriages, and courts grant a just distribution of assets and maintenance. A civil marriage can be formed from a customary. Both parties fulfill the legal criteria and register the marriage as such. Okay, registration of marriage or customary marriages. It has to be done within 3 months of you getting married. It has to be done at any Department of Home Affairs or through designated traditional healers in place where there is no Home Affairs. Spouse must represent the identification, documents, lobola agreements if available. And there should be at least one witness on both sides. So here, it's important for you to go register your marriage so that you, in the event of death, be it a husband or a wife passes away, we must be able to know how you were married. So that the family must not say, oh no, they were not done with lobola. So let me just explain this so that you understand, and it's important. Should there be a letter taken to your home as a woman, and then there's a representation of we want to marry, and they come and sit, the uncles come and sit and negotiate, and there's like some sort of money that comes out, you are automatically married in community of property if there is no antenuptial agreement before the uncles sit down and discuss your marriage. Meaning that if you're married in community of property, there is something called a post-nuptial agreement where you can sit down and stipulate your wishes as to how your finances need to be distributed or your finance needs to work. And you can have a will drafted from there so that you can safeguard your assets. Okay, recognition of customary marriages. In South Africa, this has significantly transformed the legal status, putting it into a similar footing, which was not done before. So we have a case called the Bay case, which is a landmark constitutional case, declared that customary law rules have become unconstitutional because before this recognition, only male people or men were the ones that would inherit things. A woman was not as valued as they're now valued. So now we have it in equal footing. The Interstate Succession Act is applied to the estates of individuals who died with a customary marriage, ensuring surviving spouses and female descendants have a right to inherit. We need to understand that before this recognition, females did not inherit anything because they were not legal heirs. A valid will is essential for individuals in customary marriages as it provides clarity on asset distribution, protects dependents, and overrides interstate succession. All right, polygamous marriages. In South Africa, polygamous marriages are accepted by law, but only in accordance with customary law. Neither civil nor religious marriage laws recognize them. Only marriages celebrated under indigenous African custom qualify. This indicates that they are subject to the recognition of Customary Marriage Act, which permits a man to wed multiple women as long as certain legal and cultural requirements are fulfilled. A man must request for permission from a competent court to marry a different woman if he is already in a traditional marriage. The court makes sure that each spouse's rights are upheld. The new marriage requires the first wife's approval. The new marriage requires the first wife's approval. The court must create and approve a new marriage contract. All parties' rights and obligations are governed by this contract. In community of property, which means that assets are shared, customary marriages are typically taken into consideration. To preserve the rights of the first wife, the husband must divide inheritance before getting married again. Please. Meaning prior to November 15, 2000, polygamous union consummated prior to this recognition implication were automatically recognized. But post November 15th, these regulations and contracts need court approval to be made. So before November 2000, all of these things were an automatic recognition. But after that, you have to go and get these registrations and contract approved by the court, and they must meet certain legal criteria. Okay, polygamous marriages in South Africa are recognized, but present unique challenges in estate planning. It provides full legal status to those unions, ensuring equal spousal rights and preventing joint estates. The Bey case abolished the male primogeniture rule in customary law, requiring fair estate distribution, as I mentioned. Having a valid will is crucial for a smooth and fair distribution of the estate, providing clarity and certainty. Without a will, the estate will be wound up under the Interstate Succession Act, which does not account for the specific needs of different households or the traditional values of the deceased. A will also allows the deceased to appoint an executor to manage the winding up of the estate. Key considerations for estate identifying all is in ensuring a fair division of assets in all in class. Conclusion in terms of Islamic marriages. The law governing Islamic marriages in South Africa has changed significantly in recent years. In the past, South African civil law did not completely recognize these marriages, which were formalized through the nikah ceremony. As a result, spouses, particularly women and a historic decision by the Constitutional Court in 2022, Muslim marriages are now fully recognized by South African law. In other words, spousal benefits, inheritance rights, and maintenance are all available to Muslim spouses. Civil law no longer views children born in Muslim marriages as illegitimate. In order to allow marriages, the Divorce Act and Marriage Act were modified. Okay. Registration of Islamic marriages. The nikah ceremony needs to be carried out in accordance with Islamic law. Imams, I'm sorry if I'm pronouncing this wrong, registered under the Marriage Act are required to perform the ceremony. The marriage needs to be officially registered as a Muslim marriage with the Department of Home Affairs. Unless an antenuptial agreement specifies otherwise, Muslim marriages are typically regarded as being outside of the community of property. Under the Divorce Amendment Act of 2024, Muslim marriages must be dissolved in civil courts with provisions for asset redistribution support and child custody. South African law recognizes Muslim marriages, granting them greater legal statuses. The Constitutional Court's 2022 ruling in Women's League Center Trust versus President of the Republic of South Africa declared the non-recognition of Muslim marriages as unconstitutional. The Divorce Act was amended in 2024 to officially include and recognize Muslim marriages, providing legal protection for spouses, particularly women and children, in matters of divorce and inheritance. A surviving spouse in a Muslim marriage is now recognized as a spouse for the purposes of the Interstate Succession Act. A will remains crucial for Muslims in South Africa, as Islamic inheritance law is prescriptive and has different principles than South African common law. A valid will directs the executor to apply the Sharia principles in the distribution of the estate, allows bequests, and appoints an executor. The legal recognition also brings clarity to matrimonial property regime, allowing for the division of estates according to the deceased spouse will or the laws of intestacy. Okay, policies and wills. In order to preserve your legacy and guarantee that your desires are carried out, South Africa's wills and estate plans are regulated by a combination of statutory law and useful practices. In South Africa, wills and estate policies are governed by statutory law and practical procedures to protect your legacy and honor your wishes. A valid will outlines how your assets should be distributed after your death, allows you to appoint an executor, nominate guardians for minor children, and specify bequests to family, friends, or charities. This was also mentioned by my colleague in detail. The Wills Act of 1953 requires a valid will to be in writing, signed by the testator, and in the presence of 2 competent witnesses. Estate policies and administration involved reporting the estate to the Master of the High Court, appointing an executor, and managing estates. Trusts are often used to manage assets and reduce estate taxes. Common mistakes to avoid include not updating your will after major life changes, failing to appoint a capable executor, leaving out digital assets, or not storing your will safely. Most of these, the last point was mentioned by my colleague. Wills contested. How you can contest the will and reasons. A will is contested in a legal process where the distribution of a deceased person's estate is put on hold until the dispute is resolved. Common grounds for contesting a will include lack of testamentary capacity, undue influence, fraud or forgery, improper execution, and lack of knowledge or approval. The legal process involves filing an objection, gathering evidence, mediation, and negotiation, as well as litigation. So this is when you're contesting a will, be it if you feel that the will was done under duress, or the beneficiaries were also the witnesses in the compilation of the will. This was mentioned in detail by my colleague. The contestants may be responsible for their own legal fees and those of the estate. Should you lose the case, you bear the fees. If the will is declared invalid, a previous will may be used. The testacy laws may apply, or only specific parts of the will may be declared invalid. Contesting a will can have significant consequences, including financial costs, family conflict, delays in the probate process, and the inclusion of the no contest clauses. These clauses state that if a beneficiary challenges the will and loses, they will be disinherited, with the enforceability of these clauses varying by jurisdiction. Okay, what can go into a will? A will contest is a legal process where a deceased person's estate is held pending resolution of a dispute. Common grounds, we talk about undue influence and the things that I've mentioned. Thank you, but can I give this disclaimer because it's important? I was not giving any of you legal advice, but I was giving educational advice. Thank you so much.
So far, so good. So far, I believe that we are taking something home. And after here, let me also update you that September is free wills. There's a free wills week or month. Moleboge touch on that. So make sure that if you don't have a will, Palisa, you can unmute. You can go to anyone to do a will, as Moleboge has indicated, that you can do it with a bank, you can do it with an attorney, you can do it with other organizations. But September, there's a week where wills are done for free. So even if you only have a donkey, please make sure that you have a will. We should know who to give your donkey to, or who should benefit and take your donkey.
Everyone, my name is Balisam Konza, and thank you so much for this presentation. I'd just like to ask, in regards to wills, you spoke about contested wills. Is an electronic signature enough? Does it qualify to be on a will?
If I may ask, how is everybody? Because remember, for a valid will to be valid, there has to be you as the testator, there has to be 2 witnesses and so forth. So is everybody in the room?
Yes, everyone is in the room. Or let's just assume that the will is being sent via email.
Why are we sending the room via email? Because all the witnesses must be in the same place so that the will can be valid.
Okay.
My colleague even mentioned this, that it's important that when you sign your will, everybody has to be in the room to confirm that this is not done under the duress. This is not done because you're forced or you're just making additions because somebody's putting pressure under you. This is why we talk about the fact that as a beneficiary, you're not allowed to sign or be a witness in the will.
All right. All right. Thank you so much.
Just to follow on our previous question regarding digital wills, would it be possible if all three parties are in the same room, as you specified, no one is under duress, and then everyone sign via a notepad, etc.? So there is signature, there is presence, there's no emails being sent. Would that be an accepted legal will?
I did say yes to that. Also because we're in the new digital age where you document everything digitally so that you can save it into the cloud. So there are certain times where you're allowed. For example, we now have court online where certain agreements are done online with the judge and things like that. So there are times where we then allow things like that to happen, where things can be done digitally, then you store them for safety.
If the estate can't pay all debts, example, your tax, does the in-community of property spouse have to pay half the debts out of their pocket?
That one is a little difficult, but yes, remember when you're married in community of property, it's a 50-50 situation where you guys bear each other's responsibilities, be it assets or liabilities. There are cases where the remaining spouse has to pay the debts of the spouse that has passed on, or in cases where the spouses are still alive but cannot do maintenance issues. You find that maybe, let's say, a husband has a child outside and is not maintaining the child. Now, as a wife, because you're married in community of property, you bear the responsibility to take care of the person's child because it's what's yours, it's mine, and vice versa.
So you mean that if my partner has a child out of wedlock, then it's also my responsibility to maintain that child? Or if I have a child outside the marriage?
Yes.
Now guys, this be
if you're married in community of property, you need to understand that whatever you bring into the marriage, be it good or bad, you both share the responsibility.
Okay, that's very interesting. Gloria, can you please unmute Putang Arthur? Thank you so much, Masakona. There's a question on the chat from Zoleka Sipamla. It says, if the customary marriage is not registered, is it null and void should you wish to get married again? If the customary marriage is not registered, null and void.
It's not null and void because there's evidence. For example, like I mentioned, if there was a negotiation, even if they're not done with the bride price, but there was a negotiation, there was an exchange of money, and there was some sort of celebration. Remember, the uncles have to then write down what they've agreed on. So whether you go and register it, if someone has evidence so that they can take it to court, they can take it to the Home Affairs and say, I am married to this person, meaning that you're married in community of property. You cannot marry someone else. You have to then get this marriage dissolved because should, let's say, for example, by some unfortunate accident, you pass away, and let's say your ex then says, but I was married to this gentleman in customary law. Then they can say they then can and come. And there've been a lot of issues where you do not register your marriage, but a woman or a husband says, but I was married to this person customarily. And then issues arise in that regard. So it's important to, if you're customarily married, go register your marriage. If you guys have separated, have some sort of formal documentation of the separation so that when the person says, but I'm married to this person and this is the evidence, we did not register it on time and things like that, you can then say, but we also have a formal agreement to the separation.
That's very interesting. Putang, you can come in there. Putang, please unmute yourself. You've been unmuted from our side. Please unmute yourself and ask your question, Putang. While you're still coming to unmute, Arthur, Putang, Arthur, there's a question here that was sent to me to say, if married customary, then later registered a civil marriage, and the civil marriage get dissolved, is the customary dissolved as well? So the question is, if I was married in customary marriage, then I also marry civil to someone else, does it mean the first customary marriage is also dissolved? What happens there?
While we're figuring that out, Mr. Kagiso, let me just get more information and details as to if you're saying you're customarily married and then you got married as a civil situation. Is this to the same person or to two different people? Because if it's two different people, then there's something called bigamy. If you're already married and you marry someone else, you are committing bigamy. So can I just get clarity on that?
They say it's to the same person.
Then the dissolution is valid because you did get married to this person customarily, then the civil, because remember, when you register your marriage, a customary marriage, to the deeds office, it becomes a civil union. So when you dissolve it, you are properly divorced.
Okay, thank you so much. If there's further question, they will follow up on the chat. Let me take Matlatsi and Zoleka Pamblas on the chat. Matlatsi is asking, I have a question. My partner and I each have a child from previous relationships and we plan to marry. We want our premarital assets to go to our respective children and any assets accumulated after marriage be shared equally among all children, including any born in marriage. What marital contract and type of will would best ensure this arrangement? So these two people have they met while they both have children outside marriage. Now they met. Now they want to get married. They want their previous assets to go to their children, so that they got before the marriage, and then they want the asset in the marriage accrual or income mutual property to be shared equally with the children born in marriage and outside marriage. How does that work? Advocate Masakona and Judge Moleboge.
I'm going to quickly answer this and then I'm going to allow the next speaker to come in.
It's
important to marry out of community of property with accrual, because that one says before you're married, your assets are your own. But when you are married, that means whatever you accumulate, it's shared growth. So it's important to do that. But I would also advise, or I would also suggest that get a pre-marital contract, an antenuptial contract stipulating these things to safeguard yourselves, and whatever milestone or life-changing event that happens in your life when you're married, please go update your will so that should anything happen, then you are safe. Thank you so much.
So without any further ado, I want to now bring in our next speaker who's going to talk about the trust. So now this one coming here is the Senior Counsel of the Supreme Court of Appeal. It's Ontatile Theron Sitibelo, soon to be an alumni in Diploma in Law. He's also a student in BA in Criminology. He's also a student mentor under my leadership at Student Council in Florida campus. He's also a peer educator and also a secretary to the Student Women Entrepreneurship Empowerment Program. So with that said, colleagues, can we please give a round of applause to Mr. Ontatile Theron Sitibelo, and then he will be talking about the trust and what you need to do and how to do that. I hope that you are benefiting from here, colleagues, and that you are able to take notes.
So as I was saying, that the trust is defined in terms of Section 1 of the Trust Property Control Act, which can be said to be an arrangement through which the ownership of property of an individual is by virtue of an instrument, which is a will, and which is made over to another person, the trustee, in whole or in part, to be administered or disposed of in accordance with the trust instrument for the benefit of the individual or a class of persons designated in the trust instrument, or for the achievement of the objects stated in the trust instrument. And secondly, this could be made over to the beneficiaries designated in the trust instrument, which property is placed under control of another person, the trustee, to be administered or disposed of according to the provisions of the will, or for the benefit of the individual or class of persons designated in the trust instrument, or for the achievement of the state of the objects stated in the will. And then moving to the requirement for the creation of a valid trust. So when creating a trust, the following requirements must be met. The creator of the trust must have the intention to create a trust. That is that the testator must be having an intention to make a trust, right? The intention must be expressed in such a way that a binding obligation for the establishment of the trust is created. The trust document must comply with the formalities of a will. The trust property must be determined, or at least be determinable. The trust object must be clear, and the trust object must be lawful. So we have different types of trusts. We have an ownership trust, we have a bewine trust, we have a discretionary trust, and a non-discretionary trust. We'll go deeper into this or more in detail when we're discussing the beneficiaries. Am I clear, people? Can I move forward? So a trustee. So a trustee is a person who is in control of the trust property to the advantage of the trust beneficiaries or in pursuance of an impersonal purpose. While the trustee is the owner of the trust property in terms of the ownership trust, for purpose of the administration of the trustee has no beneficial interest. In a private trust, the beneficial interest relates to the trust beneficiaries. This could be in the form of income beneficiaries or as capital beneficiaries. And a trustee is appointed in accordance with the provisions of the will. So a testator cannot delegate the power to appoint a trustee to another person. If the office of the trust cannot be filled or it becomes vacant, and in the absence of any relevant provision in the will, the master of the High Court shall, after consultation with as many interested parties as he or she deems necessary, appoint any person as the trustee. A trustee's appointment will not become effective until he or she accepts such appointment. And even after a valid appointment in terms of the will, and even after the trustee has accepted the appointment, he or she may not act in the capacity until such time as written letters of authority have been issued to the trustee by the master. Now moving to the duties of a trustee. So the duties of a trustee are determined by the trust instrument, which is the will, the common law, and the Trust Property Control Act. The duties which are laid down by the trust instrument differ from case to case. So the duties which are conferred to the trustee are different in terms of each will. So different wills will confer different duties to the trustees. The common law and the statutory duties of the trustee relate to the office which he or she holds. The office of trustee places the trustee in a fiduciary relationship with the beneficiaries. This fiduciary relationship requires that a trustee must always act in the best interest of the beneficiaries and consequently brings about unique duties. So there's a couple of duties for the trustees. We won't go through all of them, but there's a few that are included here. So a trustee must be sent to the lodgement of the will, payment of master's fees, and notice of address. A trustee must, as soon as possible, acquaint himself or herself with the trust instructions and determine the nature and extent of his or her powers and duties. As soon as possible after the issue of letters of authority, a trustee must obtain effective control of the trust property. The trustee must administer the trust in accordance with the law and provisions contained in the trust instrument. Whenever a trustee receives money in his or her capacity as the trustee, he or she must deposit such money in a separate account at a banking institution. So a trustee cannot hold the money that is deposited or that is said to be for the beneficiaries in his account, right? So that's why there's a fiduciary relationship in this regard. A trustee must, at the written request of the master, give account to the master for his or her administration of the trust property. The trustee is also obliged on written request from the master to submit any book, record, account, or document relating to his or her administration and disposal of the trust property. A trustee is also obliged to provide important information in connection with the trust to the beneficiaries at their request and owes the utmost good faith towards all beneficiaries. A capital beneficiary is therefore entitled to a complete accounting by the trustee of the administration of the trust, even for the period prior to the termination of the trust. Those are the few duties that I think we should have been going through. There's quite a few of them. Now moving to the breach of a fiduciary duty. As I said, a trustee has a fiduciary duty in terms of the beneficiaries. So the breach of the general fiduciary obligation, which the trustee owes the beneficiary, or any of the specific duties flowing from it, constitutes a breach of trust. If the elements of delictual liability are present, the trustee is personally liable to make good any loss. The provision of a court trustee is in this regard also of importance. So in South African law, a trustee cannot be vicariously liable for the actions of court trustees. Liability is based on own fault and therefore on the general principles of delictual liability. However, where two or more trustees commit a breach of trust, they will be jointly liable and severally. Due to the nature of the trustee office, it will, depending on the circumstances, be difficult for a trustee to escape liability by claiming that he or she was not actively involved in the administration of the trust. And then now moving to the powers of a trustee. A trustee's powers are determined mainly by the content of the trust instrument. While a testamentary trust does not need to contain a comprehensive description of the trustee's powers in order to be valid, the absence of such a description will make it difficult for the trustee to administer the trust, and they will probably have to apply for a declaratory order regarding their powers. Consequently, these powers will differ from case to case. The administration of the trust usually takes place over a long period of time during which unforeseen circumstances, and new needs can arise. This means that a trustee needs wide powers to ensure proper administration and disposal of trust property at all times. So it is not easy for a trustee to exercise legal powers that are not expressly conferred by the trust instrument. So if a particular power is not specified in the will for the trustee, then it'll be hard for the trustee to exercise such power. For example, if a specific power which a trustee wishes to exercise has not been expressly conferred on him or her, the proposed action may be invalid, right? It is especially important for formal acts such as the sale, the transfer, and the burdening of immovable property to be expressly authorized in the trust instrument. The extent of a trustee's power to invest trust funds is dependent on the provisions of the trust instrument and the facts of each specific case, including changed circumstances. A trustee must always act with care, diligence, and skill, which can reasonably be expected of a person who manages the affairs of another. In the choice of investment alternatives for trust funds, this implies a higher degree of care than would be the case when the trustee makes his or her own investments. Whether an investment is listed, shares, or units trust, it can be regarded as a prudent investment, which will depend on the facts of each case. And then now moving to the beneficiaries. So in a trust instrument, a distinction is made between income beneficiaries and capital beneficiaries. The income beneficiaries are benefited by means of an income such as rent, dividends, and interest, which are yielded from the trust capital, and the trust beneficiaries are benefited by way of the trust property itself, usually when the trust is dissolved. An income beneficiary can also be a capital beneficiary and vice versa. In terms of a trust with an impersonal object, the founder can or must indicate the trust object. The selection of the specific beneficiaries in accordance with the criteria of the trust instrument is usually left to the trustee. The beneficiary can be a natural or a juristic person. The beneficiaries does not need to exist at the commencement of the trust. Also, it is not necessary for the beneficiaries to have contractual capacity. However, the trust document may lay down certain qualifications regarding the beneficiaries. So the rights of the beneficiaries. The origin, nature, and extent of beneficiaries' rights are determined by the existence of a fiduciary relationship, the type of trust concerned, whether it's a testamentary trust, whether it's a trust that is inter vivos, and provisions of the trust instrument, which will be made in terms of the will. Going into the income beneficiaries. So an income beneficiary's right in respect of the trust income is mainly determined by the nature of the trust, namely if it is a discretionary or a non-discretionary trust. So number one, we'll be looking at the non-discretionary trust. So the beneficiary receives a vested personal right against the trustee at the commencement of the trust. And the content of his or her personal right is that he or she may claim payment of the income from the trustee as soon as it becomes distributable. The beneficiary in this regard does not have to wait for anything to happen before he or she receives his or her income. The coming into being of her personal right is not dependent on any exercise of discretion. So I don't know, maybe we could look at an example in this regard. Okay, while I look for that, maybe we could also look at the discretionary trust, and then maybe we can do the examples after. Where a trustee is vested with the right to elect an income beneficiary and the extent of their benefit. An individual only acquires a vested personal right against the trustee once the latter has exercised his or her discretion in favor of the beneficiary. The content of the personal right is that the beneficiary may claim from the trustee that the income which the trustee has awarded to the beneficiary will be paid out at a designated time. If a beneficiary should die after the discretion has been exercised in his or her favor, but before the payment has been made, the personal right in respect of the particular income will constitute an asset in his or her deceased estate, which can be exercised by the executor. Until the trustee actually exercises his or her discretion, the beneficiary only has an exception of being benefited. Capital beneficiaries. Oh no! Before we look at the capital beneficiaries, I think we should check the examples for non-discretionary trust and discretionary trust. So in terms of the discretionary trust, right? So we could have maybe Twala say she maybe leaves 100,000 in shares, maybe in a company, to a trustee, which could be Mr. Mekwa in trust. And then Mr. Mekwa has the discretion in this regard to choose the income beneficiaries and the extent of the benefits which will be conferred to the beneficiaries, right? So Mr. Mekwa in this regard will have the discretion to choose who will be the beneficiary and to what extent the beneficiary will be benefiting from the trust. And then in terms of non-discretionary trust, maybe Twala could then say that she leaves 100,000 in terms of shares in the company to the trustee. The trustee in this regard maybe could be then Miss Gloria. So the income beneficiary will then become whoever is appointed in that regard. It could also be Mr. Meko, or it could be Miss Gloria. Oh no, it cannot be Miss Gloria because Miss Gloria is already the trustee. So remember, the trustee cannot be cannot have a beneficial interest in any regard. So moving to the capital beneficiaries. With regard to the rights of beneficiaries in respect of trust capitals, it can be said that it is necessary to distinguish between a bewine trust and an ownership trust. So in terms of bewine trusts, at the creation of a bewine trust, the beneficiary acquires a vested personal right to the transfer or the cession of the trust property to him or her. The said personal right must be enforceable against the executor. On transfer or cession, the beneficiary becomes the owner of the trust property subject to the trustee's control. And then the ownership trust. In case of an ownership trust, it will be especially important to determine whether the ownership trust is a discretionary trust and whether provision has been made for direct substitution or not. So where direct discretion, it says non-discretion trust without the provision of substitution. So this is a non-discretionary trust where there was no provision of substitution that was made. So the capital beneficiary in this situation acquires a vested personal right against the testator's estate at the death of the testator, although he cannot enforce before dissolution of the trust or the death of the income beneficiary. The capital beneficiary does not automatically obtain ownership of the trust property when the trust is dissolved. To enable this, a transfer of the trust property or the cession of such property by the trustee is necessary. Should the capital beneficiary die before the dissolution of the trust, his vested right passes to his or her estate and can be enforced against the trustee by his executor at the dissolution of the trust. So non-discretionary trust with the provision of substitution. So in this regard, there has been a provision made for the substitution, right? So the effect of substitution is that the rights of the capital beneficiary will only vest on the dissolution of the trust. Only if the capital beneficiary is still alive does he or she acquire a vested personal right against the trustee in terms of the trust property. In this case, where the capital beneficiary dies before the dissolution of the trust, there is no vested personal right that can pass to his or her estate. The substitute then benefits in his or her place. And then discretionary trusts. Until the trustee exercises his or her discretion, none of the nominated beneficiaries have a vested personal right in respect of the trust property. They only have the expectation of possible benefits. Once the trustee has exercised his discretion in favor of a particular beneficiary, such beneficiary acquires a vested personal right against the trustee. The content of the personal right is that he or she may claim transfer or cession of the relevant trust property as soon as it becomes enforceable. This usually happens on the dissolution of the trust. The beneficiary only becomes owner of the trust property when it is transferred or ceded to him or her. And then looking into the termination of the trust. So there's a couple of factors which can lead to the termination of a trust. These are the realization of the trust objective. So if the trust was said to maybe fund or take the beneficiaries to school and the beneficiaries were taken to school, then the trust objective has been realized. Then the termination of trust will then materialize. The destruction of the trust asset without fault on the part of the trustee, the failure of the trust for some or another reason, The acceleration of rights to the capital beneficiary. This could be where an income beneficiary renounces his or her rights and no other intention is stated in the trust document. A court order in terms of Section 13 of the Trust Property Control Act, and the sequestration of the trust. That is it for me. Thank you, guys.
Oh, thank you so much, colleagues, and to Senior Counsel Unthatile.
My first question, well, my first and only question is, if someone is married out of community of property with his wife and 2 children in the marriage, but also has children out of wedlock, can the will be drafted in such a way that the husband leaves the estate to the wife, or must the children also be included in that? Thank you.
Okay, thank you so much, Nomfundo. Let's take the second one to Asanda. I hope Unthatile and Molebogang got the question. So any of the 3 will be able to respond to that question. Let's take Asanda.
Thank you, Chair. My question is on the types of trusts that were mentioned. I just need to get clarity on which one of those types of trust is a testamentary trust. And also, if you have a testamentary trust, is it necessary to have a will? Thank you, Chair.
Okay, thank you. Let me first start with the second question. Unthatile to respond to. The first question is also about the wills, and my colleagues Molebogang and Masakwana will also assist to respond. Can speak against the mic. I can speak it.
So a testamentary trust is created through a will, and it takes effect after the testator's death, right? Does that answer your question?
Sorry, I couldn't get that. Could you just please repeat that? Thank you.
So I'm saying that a testamentary trust is created through a will. So you need a will to create a testamentary trust. I guess all the trust that any type of trust that you need to create, it would have to be through a trust instrument. A trust instrument is a will. So you would need to have a will, and then in that will, then create a testamentary trust.
Thank you so much. I'm answered.
Okay, thank you.
Let's also take Nomfundo's question. She was asking about the issue of the will with the kids born there. So if you got the question, Masakona, Molebogang, and Unthatile, please respond to the questionnaire, Nomfundo. And can I also note hands, those who have any questions? Nomfundo, if you can come again, maybe repeat your question again for the responders to hear your question again.
Okay, Jay. So what I asked is, if someone is married out of community of property and they also have children out of wedlock, then can the will be drafted in such a way that they only include the wife, or is it mandatory to also include the kids as well? Thanks.
Will this be, so whose will is it? Is it the husband's will or the wife's will?
The husband's will.
Okay, so the husband also has children out of wedlock?
Yes.
Okay, so I think the children will also have to be included in the will. It could also be in the form of a trust. Maybe say that the will, the husband drafts a will that says that the wife is the income beneficiary, and then the children are the capital beneficiaries. So in that regard, when the wife passes on, then whatever is left of the will, or whatever is left, pardon, of the estate of the husband will then be conferred to the children, or will then be passed on to the children as the capital beneficiaries of the trust.
Can I quickly make a correction there on Tatile?
Okay.
Nomfundo, you don't have to include children in your will. If you don't want any of your children to inherit from your will, then you do not have to include them. You can have children and not include them in the will, whether from inside or outside the marriage. However, if they were maintained by the deceased, they can claim maintenance from the estate. However, you don't have to include them. They don't have to inherit anything. They can only claim maintenance from the estate. So your will is to your discretion. You decide who you want there, who you don't want there. So you don't have to add any children in your will.
All right. Thank you so much for
No problem.
answering my question. Thanks.
Thank you so much. I see Tsulufello's hand is up. Tsulufello, if you can come in before I take my next and the last speaker. Tsulufello Molatelo. Tsulu, please unmute. If we can unmute Tsulufello on that side. If we can unmute Tsulufello for her.
Thank you so much. Yes,
Thank
now
you.
it's working. I hope, yeah, it sounds audible because you said thank you. Thank you so much. Morning to everybody. My question is a follow-up to the previous question that was posed. Are we saying that the claiming of maintenance in the case of where there are kids left in the marriage and one of the partners passes on, right? That the remaining children can only claim maintenance from the estate and not from the living remaining spouse. And I am of this question on the basis that I believe that marriage is nullified through when someone dies. So yeah, I hope my question makes sense. Thanks.
Molebogeng Masakona on Tatile, please respond to the follow-up question from Tsulu.
Tsholofelo, can you please repeat the first part of your question? I only heard the last part. I'm sorry. I heard the part where you spoke on.
I'm asking
the late
that.
spouse. Can you please?
Yes, I'm asking that if I'm hearing the response correctly, I just want to verify if I'm hearing it correctly. With maintenance after the passing of a spouse that came with kids into the marriage, if I heard it correctly, if that's the scenario. If not, that could be the scenario. Are we saying that the children can only claim maintenance against the estate and not the surviving partner in the marriage? Or is it that the kids can claim against the estate and the surviving partner? Yeah, I hope I make sense.
So in the case of the person who passed away, they can claim from the estate, not the surviving partner. They can claim from the estate. And if you are married in community of property, they will be claiming from the joint estate. So they'll be claiming from the joint estate, but they can't claim from you personally. I hope that makes sense. They can only claim personally if both parties are still alive. You are a spouse. So they are claiming from a community of property estate. That's if both of you, you and the partner are still alive. They can only claim maintenance if you're married in community of property. I hope that makes sense. But after death, they can only claim from the estate, not from the partner.
Okay, thank you for that. Thank you so much.
The next presenter who's coming is the first presenter who started with us in terms of the wills. I don't need to introduce her again, but if you remember, part of her profile, she also worked in terms of the risk management, and she's going to be doing as administration of estate and joint estate. She's also working for an institution where she deals with wills, and she's also an independent person who has her own wills administration a company where she can assist you afterwards, but at a fee. So with that said, colleagues, that's why I'm saying I cannot be sharing people's presentations, unfortunately. only the recording will be available. So at the moment, we are going to do part 4, which is the last part. And then I'm asking you to also continue posing your questions. This is very provocative. I know some of you are really scared because now you have been in a relationship for quite some time. You don't know whether you are married or not married. Then you can check with the presenters afterwards. Molebogang, please take the session away as the final session.
Thank you. There was a question that was asked about digital signing of wills. I just wanted to make a quick correction. You cannot digitally sign wills. You need to print the will and sign it there and then with your witnesses. You cannot digitally sign wills. Those wills can be disputed and said to be invalid because it is easy for somebody to forge your signature online. So you need to sign it here and there with your witnesses. I just wanted to make that correction. Okay, so now we'll be doing administration of estates as well as joint estates. What is administration of estates? This is the legal process of winding up a deceased person's affairs governed by administration of estates. Act 66 of 1965 and the Interstate Succession Act 81 of 1987. It ensures that debts are settled and assets are distributed fairly. I just want to put something out there. Please, when a parent or a spouse passes away, whether you are an only beneficiary, you do need to go and report the deceased estate. Whether you know you are the only beneficiary, you are your parent's only child, you need to go and report the estate. Because there are some debts that you probably don't know about that need to be paid. There are tax consequences that need to be paid. So please make sure to report an estate. Don't just, after your parents pass away, you just sit in the house, you get access to everything and you become comfortable. Because if you don't change things like title deeds on houses, then it will appear. There are times where the deeds office looks at title deeds and so forth, and they see that the house is under a deceased person's estate. Then it can cause problems. Also, if you do not change or register estates and properties are changed, you become susceptible to fraud. I hope I'm clear on that. Key role players are the executor. This person manages the estate, collects assets, pays debts, drafts L&D account, and the master of the High Court, who supervises the estate process and issues all the documents required. These are steps in estate administration. I will be posting a link to an article that was done by a fiduciary specialist that you can go through the link. It will give you the steps in more in depth, and you can just go through it and read through it and see what happens when you pass away. So firstly, like I said, you need to report the death to the master. You need to report each and every death to the master so that the master is aware that this is a deceased estate. Afterwards, an executor will be appointed. This is for estates that are more than 3.5 million. If you have appointed an executor and the estate is 3.5 million and more, the master's office will ask you to get probably a lawyer to assist because that is a large estate. They do this to avoid squandering of the estate. Number 3, you advertise to creditors. So the estate will be advertised to creditors so that all creditors can come forward. You owe Rage, you owe TFG, you owe Vodacom, you once took a sofa at Russell's back then or whatever. All those creditors will be notified and they can come and claim from your estate. There have been times where a debt did not prescribe in the 3 years that we know that debts prescribed, and people from way back came and claimed from the estate for debts that were not settled in the deceased's lifetime. Number 4, collect assets and settle debts. So this is when assets are collected and all debts are settled. So if the debts are more than the money, the cash in the estate, certain things will be sold within the estate to pay for the debts. You can also appoint for your life covers and so forth to pay for any debts. To those of you who have life covers, you can appoint that a specific life cover, pay for these and that debts. This is why you need to constantly check your will and update your will. Your will is there for you to specify what is to be done. If you have debts that are under 1 million and you have a 1 million rand life cover, specify that the cover with Sanlam should go and pay for all the debts, and then that will be done. And remember that there are costs in the winding up of the estate. There are sheriffs, the advertisements are money you need to pay. I think an advertisement is 500 rand. So you need to understand that there are other costs within winding up of an estate. And when you wind up an estate, you can put it out there that a certain life cover will be used for maintenance while the winding up of an estate is done. Because remember, you cannot access a person's accounts after they pass away. So you need to ensure that whatever life covers that you have can maintain until the estate winding up is done. Then we have things such as draft liquidation and distribution account. These are things that include all of your assets and so forth. We have inspection and objections period. This is where everything is inspected. Was it done correctly? Are there objections to how the estate was wound up? Is there a debtor who's coming forward and saying, I didn't get paid? Are the other beneficiaries coming up and saying, no, I am this person's child, however, I was not included in the will, I want to contest it. This is where it is done. After debts and everything are paid, after tax is paid, this is where inspection is done. This is where objections can come forward and someone says, I'm also a beneficiary. This man used to maintain me. I am a side chick. I also want a share here. I was a beneficiary. This is my father. My father had me in his previous marriage, or my father did not include me in the will, and so forth. This is where everyone comes up and objects to the estate. The next step is distribution to heirs. So the reason why estates take time to wind up is because they need to ensure that everybody gets a chance to come and have their say. So there will be a period where they are making the estate know it is gazetted that so-and-so has passed away. You have 3 months to come and report. Were you a beneficiary? Are you a child? So that they can investigate in that period whether you deserve a share of the estate or not. And then you can go to court before it is distributed. After all this is done, we have distribution to heirs. So the reason that estates take a long time to wind up is because there are fights within that. There are people who took assets before the estate was wound up. There's money that left the estate before the estate was wound up. There is fights about the will. So estate administration can take up to 10 years. Estate administration can take up to 10 years. It can take a minimum of 18 months. It can take up to 10 years for your estate to be administered because of the process in between. Distribution of heirs is what happens at the end. So nobody gets money before SARS gets his money and before all the debts are paid. No one gets money. If by the time everything is paid and SARS is paid, there's no money, that means you do not inherit anything. Small versus large estates. Small estates which are less than 250,000 and no property, letters of authority are given. So you have the letter of authority to give this to that person and that person. However, larger estates of over 250,000 or a property that is worth more than 250,000, letters of executorship are given, and the full process that I just described is required. What is a joint estate? It exists when spouses are married in community of property. All assets and liabilities are shared equally. On death, surviving spouse keeps 50% of the deceased half forms the 50% of the deceased half forms the estate. Implications of joint estates. Creditors can claim from the joint estate. So creditors can claim from the joint estate. What this means is if your partner passes away and they had debts, as their partner married in community of property, you are liable to pay for the debt. Remember, your estate only gets separated after your deceased partner's estate is wound up. So before it is wound up and your partner has any debts, that falls into the joint estate and you will be liable for those debts. Okay, another thing, executor accounts for the whole estate, then divides. So the whole estate is put together before it is divided, right? So you and your husband share a house. That house forms part of the joint estate. Everything forms part of the joint estate. Then it will be split into half. So everything you own and everything your partner owns is one estate. It becomes one thing. And I know there are people who say, no, my partner had children before their marriage and so forth and so forth. They have a claim to their father's share of the estate, which is half of your estate. So to avoid that, this is where we say you do not get married in a community of property. Probably you get an ANC with or with accrual, whatever suits you. However, in a joint estate, you are liable for your partner's debts. The surviving spouse retains 50% share and may inherit from the deceased half. So as I said before, when it is a marriage in community of property and you have R1 million, your wife gets her 50% in terms of the marital contract. So she gets her 50% share, her 500 Rand share, and then she will get a share in your 500 as well if you do not have a will. And then there's maintenance rights under the maintenance of surviving spouses and other beneficiaries. So as a surviving spouse, you can get maintenance from the deceased estate. Beneficiaries also can come through and claim maintenance. Practical challenges, disputes between heirs and surviving spouse. Those are the problems with joint estates. They are going to be disputes between heirs and surviving spouse because you are fighting and saying, no, this is my estate. However, you must remember that it is a joint estate. For as long as the deceased estate is not wound up, it is a joint estate. And then there's property division complications. So you must remember that you cannot split a house in half. We cannot take a chainsaw and split a house in half. So that is where we say property division complications. Because you are saying, one person is saying, no, let's sell this house and then share the money 50-50. The other person is saying, no, I live in this house. How do you want me to share my husband's house? That is where property division complications come up. There are things that cannot be split in half. Things like the house, things like the car, they cannot be split in half. So it causes complications where a spouse owns half of the house and a child owns another half of the house. The child wants the house to be sold and the spouse does not want the house to be sold. Lengthy process, so it can take as little as 6 months. I'm not saying the maximum is 24 months. It can take up to 10 years because of all of these disputes. These are the challenges that we have. Executor mismanagement risk. Sometimes your executor mismanages your money. That is another risk. This is why when your estate is more than 250,000, they ask that you bring in an advocate to assist your executor or another financial professional that could be an accountant or so forth to come and assist. Importance of estate planning. Draft a valid will and keep it updated. Choose correct marital regime. You need to know the marital regime that you are married under. My colleague, Ms. Masakona, explained that when this and this happens, it is customary marriage, and that in turn means community of property. You need to be aware of what marital regime you are married under. Keep records of asset and liabilities. This will help your executor if you have a file or something where you say, I owe ABSA a loan of this and this much. I owe this and this much to Capitec. I owe Rage this much. I owe that much. It helps. Keep track of your assets because sometimes assets can get lost in the process. A person passes away and they have a car that they took to the mechanic, and the family forgets about the car or they think you sold it, the mechanic gets the car. You need to keep records of all your assets that are under your name as well as your liabilities. Nominate beneficiaries on policies and retirement funds. Like I said prior, your policies and your retirement funds all have their own beneficiaries. When you create a policy, you are asked to nominate a beneficiary. So you can't go and change a beneficiary in the will, yet you nominated somebody at the pension fund. If you want to change that person's name at the policy, contact your policy and have that changed. In terms of retirement funds distributing, retirement funds work at their own discretion. There are rules that retirement funds work at. Yes, you can name beneficiaries, but retirement funds can later change that. If a person comes and claims and says, no, I was a beneficiary of this person was maintaining me monthly, they can come and claim. So with retirement funds, you can say 50% to this person, 20% to this person, 10% to that person. However, they can claim from that. They have their own discretion. Retirement funds have their own discretion. Seek professional legal advice. When drafting your will, when becoming an executor and everything, always seek professional legal advice. Seek professional legal advice so that you know that you are within the bounds of the law. Also remember, you can draft your own will. However, to ensure that things within your will are valid, seek professional advice, seek advice. The key takeaways for this is that estate administration ensures fairness, order, and compliance. Joint estates require balancing surviving spouses' rights with heirs' claims, and good estate planning prevents disputes and delays. What we mean by good estate planning is creating your trust, having your will, ensuring that when you pass away, things are the way you want them to be. It does not help to procrastinate and say, I am going to create a trust. This is what's going to happen when I pass away, yet you don't have it on paper. Have everything on paper. Have everything written down. These are the forms that are used in administration of estates. These are just forms you can know about. The death notice, which is the form J294. It notifies the master of the death, all cases. Inventory form J243, it is a list of assets and liabilities that is due within 14 days. Nomination. So the other thing is that the master doesn't quite keep record of how long you do these things, but the more you delay is the more the estate takes long to wind up. Nomination of executor, which is form J190, confirms nominated executor or representative. So you can nominate an executor. However, at the end of the day, the master has to approve that nominated executor. It is at the discretion of the master to approve or disapprove based on whatever reasons they give. Acceptance of trust as executor representative confirms an appointment. That is the J190, the J197. Undertaking of acceptance of master's directions, form J155 for small estates of under 250 and no property. L&D account lodgement forms, it is the J182, it is submitted with advertisements. What is a liquidation and distribution account? It is the central document in estate administration. It shows all assets, liabilities, and how estate will be divided. The purpose is ensures transparency, protects beneficiaries and creditors, gives master approval basis. The process, the executor drafts the account, lodges with the master, advertised for inspection, which is 21 days. If no objections, confirmed and assets distributed. What happens if there are trusts? The inter vivos trust, this is created during your lifetime. This is a separate legal entity, not part of deceased estate. Trustees continue managing assets under trust deed. Executor only reports deceased interest benefit in terms of the trust. So whatever is said in terms of that trust in the will be done. However, remember that this was a will there was a trust that was created during their lifetime, so it does not form part of the estate. Testamentary trusts are created in a will. So if you say, I take my life cover and my pension fund into the trust, this is where the testamentary trust is created. It is created because of your will after death. It comes into effect after death. It is used to protect minors, disabled or vulnerable dependents. I know somebody asked a question, if you have a vulnerable child, a disabled child, this is where you put in information in your will about how this trust is to work. It is used to protect minors. These are kids who are still in primary school, the disabled or vulnerable dependents. Sometimes you have older parents who need assistance. This is where you put it in that you'd like a nurse to be appointed, and the money from the trust or the interest paid in the trust will pay for that. Executor transfers asset into trust after the estate is finalized. So after everything is paid for, everything is done, all debt is done, then everything goes into the trust. The trustee manages assets until conditions are met. You will decide when my child is 21, you can close down the trust and they can get the lump sum of what is left. When my child is 25 and gets a degree, they can get what is left there, or at that point, whatever money is there can be used to buy them a car and buy them a house, and then what is left is going into a savings account. You get to decide what happens when it is closed and so forth. The executor's role with trust is identify if the deceased was a trustee, replacement may be needed. If the deceased was a trustee somewhere, they may need to be replaced. If the deceased was a beneficiary, note rights for estate valuation. Ensure testamentary trusts are established per will. The executor is there to ensure that your testamentary trust is established as per what you required. If money, you have a house, that rental house is going into the trust, you are saying money from my rental rooms will be used to pay for so and so. Each trust has monthly fees, monthly administration fees. So if you have, that'll depend on where you have your trust done and so forth. But I do know that you can register a trust, you can create and register a trust. It must be registered with the master's office so that they know and are aware of what is going on within the trust. So a key takeaway, trust assets are not part of the estate unless the deceased retained control or benefit. My colleague Untatile spoke on this. So trusts that are created are not part of the estate. Any trust created prior does not form part of the estate. Thank you very much. That concludes the end. I will be looking at questions and you can raise your hand if there are any other questions.
And I saw also on the comments and the questions there's also some corrections that need to be done. Colleagues, we apologize for the errors that are made in terms of the value of the estate, whether it's 250,000 and above or it's 3.5. I think that will be corrected in the chat because I think someone corrected you to say, according to law, it's not 3.5, it's I think it's 2.5 or so. We'll get the correct information to be shared. But as we said, that September is yes, Molebogeng?
Of the estate value. I'm really sorry for that. I was thinking of the estate duty tax. Thank you for the correction.
Okay, thank you so much. Yeah, we are all human and we accept your apology. And thank you. It means that my audience are well learned and they know to do their research. So colleagues, don't accept things blindly and accept everything you hear on the streets. Don't take TikTok and the Reels legal advice and don't consult properly. So please consult. We see during the presentations the errors that we are making, some of our parents that they made, some of our siblings, they died. I see the questions are on the chat. So Untatile is here with me answering some of the questions. Masakona is also answering. Molebogeng will also go back there to answer. So can I take the last few hands? Let me take 5 hands now. Kutlwano, Joy, Agnes, Tapani will be the first one to ask a question. Let's unmute Kutlwano. Can I ask you to raise your hands? I'm going to be generous now to take 5 hands. I still have a few minutes to go. Kutlwano, you are on the floor.
Afternoon, everyone. Thank you for the presentation. I wanted to ask in terms of the estate, if the scenario is that we are left with the estate, winding up of the estate, and we are at the part where we have to pay the shortfall of the liquidation and distribution account. That's where we are currently. The amount is a big amount, and the family doesn't have ways to pay it off. What kind of arrangements do we do with the lawyers who are administrating the estate, and can we also ask them to help us sell off some assets? And yeah, how do we do that?
Okay, good one. So if there are assets that are immovable that can be sold, then you will speak to the attorneys to solve them. However, if the estate does not have any money, you are not specifically as beneficiaries liable to pay for that unless you are the person's spouse. However, the estate can be said to be insolvent. The estate does not have money, then the estate will be closed. You can go to the master's office and with accounts and everything and tell the master the estate no longer has money. You do not have to pay from your pockets. However, if there are still things like houses and so forth within the estate that belong to the deceased, then you will have to sell such assets.
Okay, there are some immovable yeah, we are thinking of selling the movable assets at least just to help cover some of the costs. But yeah, I feel like the wife to the deceased is being held liable to cover the shortfall in order to close this estate thing. And we are also thinking of doing a trust because yeah, it's been almost 8 years that this has been happening.
Which is why I'm saying if there are still properties belonging to the deceased within the estate, then they will be liable to pay for the estate to wind it up. So you'll need to sell the houses if they are there and so forth. However, if there isn't anything anymore, then you can close it up with the master. However, if they are married in community of property, then the person is unfortunately liable for each and every other debt that's still there.
Okay, thank you very much.
I have a situation here. Okay, there is these two people, it's a man and a woman, and then they get married. And then at a later stage, they divorce. And then after a few years, they decide, okay, let's try. Okay, I was saying there are these two people, it's a man and a woman. They get married, and then later on, they get divorced. They come back again, reconcile, but this time they don't get married. And then they buy a house as a joint bond. And later on, they go their separate ways again. And then the man now marries another woman in community of property. So now what happens to that house, the joint bond house? And then how can the situation be resolved?
So my question this time now with regards to the administration of the estates. Let's say the estate has been there for about 10 years after the deceased has passed away and no one has come forward, but then you find that there's still an opportunity to come forward. Now you find that there's only the house left. And I know that if the estate is over 250,000 rands, you need a letter of executorship. Is it enough to get the letter of executorship only for now, whilst you are still gathering funds to complete the transfer of the property to maybe a surviving child or grandchildren? That's the question. Thank you.
For the first question about the shared house, the what can be done in this cause is because one of them had a joint bond with the previous partner and then remarried, the new partner has a share in the house. So what can be done is for the house to be sold, or they get one of them to buy the other one out of the house. So if it is the shared houses with the ex-wife, then the new wife the ex-wife may need to buy out the new wife from the house. I don't know if that makes sense.
Understood. Thank you.
Okay, I didn't really hear Buitumelo's question I don't know if she can please repeat it. Bitumela, can you please repeat your question?
Okay, sure. So my question again is, state, you find that it has not been claimed for about more than 10 years, but there is still surviving, there's still surviving children and grandchildren who want to now administer the estate, but you find that it's only the house that's left and they don't want to sell it. So is it enough for them to get a letter of executorship in the meantime, whilst they're still gathering money to complete the transfer of the property, maybe to a surviving child or grandchild?
So in that case, if they'd like to keep the house, we have what is called the family house clause. They can go to the master and register the house as a family house. You don't have to go through the winding of the estate. If you go to the master's office, they will advise you on how to go about that with the house and then with transferring the deed to all the people's names. So you can just go to the master's office for that. But this is why it comes into play, where you have to report the estate though, and then you will report that only the house is left. If there are no debts, no debts were incurred throughout, this means you have been paying for services on the house and all of that, then that will be a rather fast process.
Oh, okay. Thank you so much for that. And even if the house is over the 250,000 rands, it's still possible as long as it's not owing.
If it's over the 250,000 rand, they may need to pay the estate duty, because I know, not estate duty. However, you can get the letter of executorship for that. I'm sorry, I keep confusing the estate duty and the letter of executorship. I'm really sorry. However, you can report that to the master, and you will be advised accordingly to that. I'm not quite sure on this. However, this is what I'm saying. Please just report it to the master and find out what the process would be.
All right. Okay. Thank you so much. I'm answered.
All right. No problem. Thank you very much. This is
Thank you so much.
closing
Yes.
from my side.
So if you have an estate that is over 250,000, you need a lawyer to get the letter of executorship. Is that correct?
You don't need a lawyer. However, because the estate is so big, you are advised to get another professional. There are allowed professionals, I think lawyers, accountants, and so forth, to assist with the winding up of the estate, because it is seen as a large estate. So you can appoint an executor who will assist in overseeing what the lawyer does, because the estate is so large. You will not be allowed to wind it up alone.
Oh, okay. All right. Thanks for clarifying that.
My name is Rape. I am a trainee career guidance practitioner from the Sunnyside campus. And on behalf of the Counseling and Career Development Unit, I'd like to say thank you to everyone for being here today. I'd like to make a very special thank you to our speakers. We appreciate the time and effort you took to share your knowledge with us. Ms. Molebogang, thank you for explaining the importance of making a will and giving valuable information about estate administration. You helped us understand how different types of wills work and why planning ahead is important. Ms. Masakona, thank you for teaching us about different marriage contracts and the laws that guide them. This information is very useful and will help us make more smart decisions in future. Mr. Untatile, thank you for explaining the requirements of a trust and different type of trusts. Your talk was very clear and gave us helpful information for planning and protecting our assets. To all the students and attendees, thank you for joining and engaging. We hope that you have learned a lot and that will help you make good decisions in life. Lastly, thank you to the organizers for organizing such an informative workshop. Once again, thank you to everyone and have a wonderful day.